Welcome to the September edition of This Month in Payroll. I'm Claire Soccio, a partner in PwC's payroll advisory practice. Today we're taking the unusual step of committing the entire edition to just one topic, being the Federal Court's judgment in the litigation between the Fair Work Ombudsman and both Woolworths and Coles. This landmark decision has potential implications for any employer paying an annualised salary to award-covered employees, not just those in the retail sector. Joining me to discuss the case and the lessons and actions for other employers is Natalie Perrin, a partner in PwC's workplace law practice. Welcome, Natalie.
Thank you, Claire.
Now, this decision extends across some 200 pages, has been over 2 years in the waiting, and there is still a case management hearing which, at the time of recording, is scheduled to take place in mid-November. So for this episode, we're narrowing in on 3 key elements of the decision that we consider to have broad application. These are the operation and limits of offset clauses in employment contracts, record-keeping obligations in respect of salaried employees, and expectations when employers and employees agree to vary award obligations. Nat, can you please start by explaining the rather unique origins of this mega decision and how the two supermarkets ended up parties to the same litigation?
Absolutely. Thanks, Claire. There were originally 4 proceedings in the Federal Court of Australia. There was a proceeding brought by the Fair Work Ombudsman against Woolworths, a separate proceeding they brought against Coles, and then 2 separate employee class actions against Woolworths and Coles. The 4 claims centred on alleged underpayments by Woolworths and Coles to their salaried managers who were covered by the General Retail Industry Award, or GRIA as it's frequently shortened to. A decision was made to consolidate and hear the 4 proceedings together, with the intent being to efficiently address common questions, ensure consistency in the interpretation of the relevant laws and awards, and avoid duplication of evidence and arguments across multiple trials. The trial was heard between June and July 2023, and the Federal Court delivered its long-awaited judgment on 5 September 2025.
With that context, let's start with the first key theme being offset clauses. Those are the provisions in employment contracts that seek to set off an annual salary against the different entitlements an employee may be eligible to receive under an award, such as minimum wages, overtime, penalty rates and allowances. In this case, Woolworths paid its salaried managers on a fortnightly basis, and it sought to apply the offset clauses in its employment contracts over a 26-week period. Coles paid its salaried managers on a monthly basis and sought to compare the total salary against award entitlements over an annual period. Many employers have similar arrangements and have long sought clarity about whether it is permissible to pool and compare the total salary paid against award entitlements across a longer period. So Nat, what did the Federal Court decide on this point?
The court ultimately held that the offset clauses are only effective within a single pay period. In other words, an employer can only use the salary amount paid in a particular pay period, whether that's fortnightly or monthly, to offset the award entitlements that would otherwise have been payable in that same pay period. So they can't average across pay periods or bank overpayments in one period to cover underpayments in another. In reaching the decision, the court was satisfied that, as a matter of contract law, parties can agree that a salary payment's intended to satisfy multiple award obligations, but it looked at Section 323 of the Fair Work Act, which requires employers to pay employees in full and at least monthly, and the GRIA, which requires payments due to employees to be paid on a weekly, fortnightly, or in some cases monthly basis. The court then concluded that employers must pay all award entitlements that accrue in that pay period in full stop.
This is a fundamental shift from the way many employers have historically managed annualised salary arrangements. There are many examples where, for example, due to peak periods, seasonal demands, or maybe even the need to cover other staff absences, employees' hours of work do go up and down across pay periods. And many employers haven't reconciled this every pay period, instead taking the view that they needed to pay a salary that was at least enough across a longer period, such as a year. From the employee's perspective, many also prefer to receive a regular, consistent salary each pay period. So I'm keen to explore where this leaves other employers. Nat, can you clarify which annual salary arrangements are actually most likely to be impacted by this offset decision?
Of course. So those employers who pay a contracted annualised salary to an employee who's otherwise covered by an award, whether that be the GRIA or another award, they're the most likely employers to be impacted directly by the court's findings on set-off. By contrast, the principles don't necessarily extend to employers who pay an annualised wage in accordance with the term of an award that permits such an arrangement, such as the Banking, Finance and Insurance or the Clerks Awards, or an annual salary under an enterprise agreement, or arrangements such as IFAs, being an individual flexibility agreements, or a guarantee of annual earnings.
Let's now turn to the second major theme from the judgment, which related to record keeping. This is an obligation many employers have grappled with, specifically how they meet their record-keeping obligations while also creating a culture of trust and flexibility for their salaried staff who are otherwise paid a fixed amount each pay period. The retailers in this case argued that because their salaried employees were paid an all-inclusive salary, they did not need to keep records of overtime, penalty rates or other specific entitlements, as they weren't payable to those employees. So Nat, can you take us through what the court had to say on this issue?
So the court looked in detail at the record-keeping obligations set out in the Fair Work Act and the regulations. It found that the obligation to keep records is triggered by the employee's entitlement to be paid certain amounts under the award. Even if an employee is paid a single salary that's intended to cover all entitlements, the employer must still keep records that allow the calculation of those entitlements and to make sure they're sufficient to cover the award. This matters for two reasons. Firstly, the failure to keep those records itself is a breach of the Fair Work Act. But record keeping is also, it's not just a tick box requirement for compliance. It becomes the foundation for defending underpayment claims and for demonstrating that employees have received their lawful entitlements. Where an employer fails to keep those records, the burden of proof can shift to the employer to disprove underpayment allegations.
What really stood out to me, and is particularly relevant for our audience, was the court's detailed commentary about the substance of the records. It found that roster and clocking data does not provide the specific details required by the Fair Work regulations that Nat referenced. Rosters typically show only the hours an employee was scheduled to work and not the actual hours worked, so they may not reflect changes, overtime or variations in real time. Clocking data, while more accurate in recording start and finish times, doesn't necessarily capture the reasons for additional hours or whether breaks were taken when required. And as this case showed, this data can be flawed as employees can forget to clock out or they may clock out twice. Neither of these data sources categorises the hours worked into buckets, such as those attracting ordinary time, penalties or overtime, or shows how those resulting entitlements are actually calculated.
That's right, Claire. The court emphasised that the law requires employers to keep records that clearly set out the details of each entitlement, such as the number of overtime hours worked, when overtime started and finished, and the basis for any loadings or penalties paid. Simply having that raw data from rosters and clocking systems was not enough. The records must be in a form that's readily accessible, understandable, and sufficient to allow both employees and inspectors to verify that all entitlements have been properly calculated and paid. So let's explore whether decisions about offset and record keeping leave employers. For those employers who are paying a contractual salary to award-covered employees, it's important to firstly understand those current arrangements. If you have offset clauses that seek to operate over periods longer than a pay period or longer than a month, these may not be effective. You may therefore be exposed to underpayment claims for particular pay periods, even if across the year the salary is generous enough to cover those entitlements. You also need to consider what records are currently being created and retained for salaried employees, and whether these records provide the necessary level of detail, such as the ordinary hours worked, overtime hours worked, penalty rates, and enough to calculate the entitlements. Also understand the reverse onus that I just touched on. If you fail to keep proper records, you may have to prove that you have not underpaid employees. It's a difficult task if the evidence is missing or incomplete.
Employers also need to consider the appropriate way to monitor and assess compliance each pay period. Some systems will handle this reconciliation more seamlessly than others, so this may involve a review of whether current system capability and processes are fit for purpose. There may be a need for additional investment into systems, as well as supporting processes, additional payroll resources, training and change management. Asking your salaried population to record their hours of work can be a significant cultural shift, so requires strong leadership, communication and engagement with any impacted staff to support a successful transition. And lastly, it might be possible to strengthen rostering and workforce management practices to minimise the circumstances where salaried employees work patterns that trigger excessive award entitlements. Policies can also be reviewed to tighten controls around the working of unplanned or unauthorised overtime. The third key finding focuses on award clauses which allow employers and employees to agree to vary certain award conditions. Some examples include reducing the break between shifts from 12 to 10 hours, varying roster patterns, or taking time off in lieu of being paid overtime. Many modern awards allow for certain entitlements to be varied by agreement. So again, this finding has potential impact beyond retail employers. Nat, what were the court's conclusions on agreement?
The court provided some important guidance on what constitutes a valid agreement in these contexts. We can talk about this in 3 key points. 1, there must be a genuine meeting of minds. The objective circumstances must show that the employee was aware of the entitlement they are giving up and that they agreed to forego it. Number 2, awareness is the key. It's not enough that the employee simply works a shift or accepts a roster. There must be evidence that the employee understood that they were waiving a right, such as overtime or other entitlement. And 3, onus of proof. If an employer relies on an agreement from an employee to vary an award entitlement, the employer bears the burden of proving that a valid agreement was reached.
This is a significant clarification where in practice many employers rely on the acceptance of rosters and informal practices, such as employees agreeing to swap shifts or work different hours without necessarily documenting that agreement or ensuring the employee understands the implications. In fact, in this case, we saw some examples where the employees themselves were responsible for rostering, and even the act of scheduling themselves into certain pattern, for example with a lesser 10-hour break between shifts, wasn't considered sufficient evidence that they'd actually agreed to vary these award conditions. So what steps can employers take to strengthen the validity of the agreement with salaried employees, where an award allows for entitlements to be varied?
Firstly, inform employees. Make sure employees understand what they are agreeing to, and if the agreement results in reducing or removing award entitlements, make sure they understand what rights they are giving up. This may require providing information in writing or having a conversation to explain the implications. But then document all agreements and ensure that the employee's awareness and consent are clearly recorded. Also consider reviewing policies and practices. Check that your rostering, time off in lieu and other flexible work practices comply with the requirements under the relevant award. Identify where informed agreement is needed or where agreement under an enterprise agreement is needed. And also don't make assumptions. The fact that an employee works a particular shift or accepts a change does not by itself amount to a valid agreement.
It's important to note that the decision also discusses a number of other specific entitlements and clauses in the GRIA. Examples include how to determine and apply extended spread of and number of ordinary hours based on trading hours, the rate at which the short break penalty should be paid, and a range of clauses that impact entitlements to overtime and how to calculate overtime. While we haven't gone into all of these today, employers should inform themselves of these details and consider if their current practice aligns to the decisions detailed in the case. While this federal court decision involved 2 of Australia's largest retailers, the implications should be considered by all employers who pay annualised salaries under an award, regardless of industry or size. The risks and consequences of non-compliance are significant, not only in terms of back pay, but also penalties, reputational damage, and the administrative burden of a historical remediation. While we won't know for some time whether this decision will be appealed, employers should, at a minimum, assess their current practices against the key expectations set out in this decision. This will identify whether there may be dormant risks and allow you to make an informed decision about the appropriate time and pace at which to address those risks. I'd like to thank Natalie Perrin for joining me today. We'll continue to monitor and share with you future developments from this case over the coming months. Before we close, we invite you to register for our next Workforce Leaders Forum. Payday Super is set to begin on 1 July 2026, and with only 10 months remaining to prepare, we'll take you through the practical implications of the new regime, including onboarding, payroll processing, remittance and rejection management, and real-time exception testing. You can register via the link on your screen. That's it for our September edition of This Month in Payroll. If you'd like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to me or your usual PwC contact. Until next time, have a great month in payroll.